Welcome to our attendees. My name is Danielle. I am the newest face you'll see at the Sacramento District Dental Society. I am the Director of Membership and Engagement. And so I'm just going to go over a few announcements and introduce our speaker and get us started. So just so you all know, this webinar is being recorded. For attendance verification and to get CE credit, please add your name into the chat box. Rename your screen name as needed. CE certificates will be sent with the survey by email tomorrow. If attending as a group, please type in all participant names into the chat box as well. And during the session, you can type any questions you have for Mary in the Q&A box, and we will answer as many of those as we can at the end of the course, being mindful. Give me 1 second here. Being mindful of the time. If you have any other questions, such as technical issues, please ask them in the chat box as well. So please welcome today's speaker, Mary Bradford. Mary is, I apologize for the beepings that are going on in my office that have literally never occurred, so until I get onto a Zoom. I'm so sorry. Please welcome today's speaker, Mary Bradford. Mary is an HR director for the California Employers Association. She has a Bachelor of Arts degree in Organizational Communications from Cal State University, Sacramento, and her PHR and SHRM certifications. Before joining CEA in 2005, Mary held HR manager positions for both small and large companies, and is familiar with the challenges that each can face while running a business in California. So, Mary, I will turn it over to you.
Great. Thank you so much, Danielle, for that introduction. Welcome, everybody. Really glad that you're able to join us. You might also be seeing on your screen Anna Manzano, who will be in the chat box if you have any technical issues. She is your go-to. And then again, if you have any questions for me, go ahead and throw them in the Q&A box, and I'll make a couple of little pit stops so we can make sure that we're answering any of the questions that you have. So thank you both for today, and let's go ahead and get started to talk about our labor law update for 2024. So the first thing I want to remind everybody is, and I see lots of familiar names on the participant list, so glad that you're here, but if you have not called the HR hotline yet, sponsored by SDDS, the time is now, because it's the start of the year. There's always lots of questions, lots of new laws that come out. And I have been with CEA as long as we've had the HR hotline for SDDS. So it's been a couple of years now. So do make sure you're utilizing this. It's a wonderful benefit that SDDS provides to its members. Make sure you give us a call Monday through Friday, 8 to 5. This is your direct line, the 888-784-4031. So make sure you're calling that number. You're going to see our main 800 number on all of the slides, but we do ask that you call that SDDS hotline number so we know who's calling when you give us a call. But we can help you with a wide range of topics besides just the labor law update I'm going to go over today. If you have other leave of absence questions, if you need help with harassment prevention, discrimination issues, just things going on in the office, feel free, give us a call anytime. We are very happy to help you. You can also send your question to ceainfo@employers.org, because I know sometimes you might think of a question at not the best time, or you're so busy with patients that you can't necessarily pick up the phone to call. So always feel free, give us a call, ceainfo@employers.org, or our email. All right, quick legal disclaimer. Keep in mind, CEA, we are not a law firm. So what I'm going to talk about today, please don't rely upon this as legal advice, although I'm talking about bills, assembly bills, and Senate bills, and laws, and all those kind of good things. CEA is not a law firm. So when you call to speak with me or any of the colleagues that I have on the HR hotline, we're not giving you legal advice. We're giving you as much information as we can, so you kind of have an idea of what your options are, but ultimately all of those decisions are up to you. We do recommend that you do have an attorney that you can consult with if there ever is a matter of legal significance where you need a little assistance or you need to just have an attorney in your corner. And then who is CEA besides the people who answer the phone when you call us at the HR hotline? Well, we have been around since the 1940s, late 30s, early 40s here in California. It started out in the Bay Area. We're based in Sacramento, though. I'm just in Roseville. We have numerous HR directors that are all over the state, and we've worked with SDDS, as I mentioned, for a long time, but we have lots of member dentists too. So we're very familiar with the challenges that you have in your offices, which you have to deal with a lot. And our job is to try to make your life a little easier by bringing you peace of mind. You are busy being wonderful dentists and wonderful office managers and business managers. You don't have to be HR experts. So give us a call and we will try to make your HR life a little bit easier. So here's what we're going to talk about today. We have quite a lot to cover in the next hour. I've tried to give you a good overview of what's going on in the labor law world. Some of these you might think, well, I'm not too worried about that. And that's wonderful. But keep in mind, sometimes these things that start out small start to become bigger and start to affect a lot more employers or small employers as well as large employers. So we're going to talk about all those today. So certainly one that you're dealing with right now is the new paid sick leave expansion. We'll talk about that. There is a new reproductive loss leave benefit in California. If you haven't heard about it, you're going to be hearing about it. Marijuana and cannabis use rights in the workplace for employees. We also have a new plan that you're going to get to put together later on this year, workplace violence prevention. So we'll talk about that. And then, of course, we're going to spend some time in wage and hour because I know that's a big issue that you have to deal with a lot. And then I'm going to throw in a couple of other agency regulatory changes just so you can kind of see what's going on out there and you'll be up to date on all the labor law things. So if there was ever a time of the year or a year to do a handbook, 2024 is your year. So if you have not updated your handbook in the past year and you haven't updated it for 2024, I promise you it's out of date. One of the things we're going to be talking about today is the NLRB, which is the National Labor Relations Board, and they have the NLRA, which is the National Labor Relations Act. And they have been getting increasingly ingrained in regular businesses, not just union businesses. And they want you to be very aware of what you're saying in your handbook. So there are some changes that are needed in the handbook for 2024. Also, some of the leaves we'll talk about: paid sick leave, of course, reproductive loss. You really want to make sure your handbook is up to date and accurately reflects what the law requires you to provide, as well as just what you do every day in your business. So this is a year, make sure you get your handbook updated. Again, there's our email. If you have questions on that or policy issues, send us an email. We'll be happy to help you out and get you on the right track for that. So let's start by talking out about leave of absences, because I know this is a big issue sometimes for your office, especially when you're trying to run lean as it is, and then you have someone taking some time off. Gets to be a little hairy out there. So let's start by talking about paid sick leave. The first thing I'd like to say about this law is it's really not that different than what we've been dealing with for the past couple of years. So as you all know, since 2015, you have been providing paid sick leave to your employees. It started out with just 3 days or 24 hours of paid sick leave. Now they've just increased it. They've talked about doing this for years. As you remember, depending on your employer size, there was also supplemental paid sick leave during COVID time. That is all gone. And so the idea was, well, we don't have supplemental paid sick leave for COVID. We're going to increase our general paid sick leave a little bit. Now, the good news is they had talked about having this be 7 or 8 days, and they were able to get it to 5 days. So what you now need to provide to your employees, and this is to all of your employees, is 5 days or 40 hours, whichever is greater. We'll talk about that in just a moment, but that's the minimum that you've got to provide to your employees. Now, as far as how you give that to your employees, that has not changed at all. You can still do a lump sum method where you just drop 40 hours every year into an individual's paid sick leave bucket, or you can use the accrual method where they accrue 1 hour for every 30 hours that they work. So then it's accruing a little more slowly versus just dumping all those 40 hours into the paid sick leave bucket. Now, the other change when it comes to the accrual is that there are new caps. So the new cap is that your employees can accrue up to 80 hours or 10 days of paid sick leave, but you as a business can still limit their use to 40 hours per year. So even if they accrue more, you can still say you're only allowed to use 40 hours per year. And again, that accrual rate is 1 hour for every 30 hours that they work. So this is where you might want to consider what is the best thing for my office. And I always say, please do whatever helps you stay as sane as possible because you've got a lot going on. There's a lot to manage. Does it make more sense for your office to just dump those 40 hours January 1st into everybody's bucket? Fantastic. If that works, great. If you'd rather do the accrual method, so they're just accruing based on hours worked, fantastic. If you want to have two different plans, you can do that as well. So a lot of offices I've talked to, they're doing the lump sum method for their regular staff, and then perhaps they're doing the accrual method for hygiene. If they have a hygienist that only comes in 1 or 2 days a week, they would rather they're just accruing that time based on those hours that they work. So it's completely up to you. You can have two different plans if you want. You can have everybody on accrual, everybody on lump sum, or a combination of that depending on their employee classification. So do what works best for you. Now, the other thing to keep in mind is what to do if you're using a different accrual method. So say, for example, you have a paid time off plan where you have your vacation and your paid sick leave all lumped in together. Now, this is a big change for those of you that do that plan. So if you're using what's known as an alternative accrual method, what you now have to do is guarantee 24 hours of paid sick leave or paid time off for your employees by the 120th day of employment, and they have to have 40 hours by the 200th calendar day of employment. Now, this applies to your hourly employees, your exempt employees, your part-time employees, your full-time employees, if you're doing an alternative accrual method. So this is why we've been talking with a lot of businesses, and not just dentist office, but businesses in general, who are separating their plans now. So they're having a standalone vacation plan and then a standalone paid sick leave plan. Just because we recommend it in general, it just makes it a little easier to manage when you've got paid sick leave on its own and vacation on its own. But also when you have a PTO plan, so you combine your vacation and your sick, it's all in one plan. Essentially, your PTO plan is just a giant paid sick leave plan, and you have to make sure that plan meets all the requirements of paid sick leave, all the protections, and all the flexibility of a paid sick leave plan. So you might want to give us a call at the hotline if you're interested in discussing how to kind of break those plans apart. But we're seeing lots of businesses do that just because it's becoming increasingly difficult to just have a PTO plan for California. So you might be thinking, okay, well, great. We use the lump sum method and we give that to the employee as soon as they're hired, or perhaps you use July 1st as your anniversary date for dumping in that paid sick leave plan. So in the past, we gave 3 days or 24 hours. Can we just wait until the next anniversary date? So say, for example, can we wait until July 1st to give them those 40 hours? So the answer is no. The state came out and said, nope, your employees need to get that time earlier. So you can either put in 2 additional days as of January 1st and then give them 24 more hours as of July 1st, if that was your anniversary date. Or what we would recommend, again, just as a suggestion to make your life a little easier, go ahead and just dump that lump sum of 40 hours into their paid sick leave bucket as of January 1st. And then it's just going to reset every year. Because remember, when you use that lump sum method, you're just resetting that amount every single year. It doesn't have to be paid out. It doesn't have to be rolled over. Lump sum can be reset. When you use the accrual method, that is that rolling accrual that you do keep that amount going, and you can cap it. Again, you can cap it at 80 hours and it's limited to 40 hours per year, but that's kind of the pros and cons to that lump sum and that paid sick leave accrual. So we recommend if you're doing that lump sum, it's probably easier, just go ahead and reset your year to January 1st. And then every January 1st, you're putting the 40 hours in that bucket. So how in the world are you going to address all these new paid sick leave requirements? First thing, you've got to update your handbook. Make sure your handbook reflects what you're doing. And this could be a great time for you to decide, what are you going to do? Are you going to change to a lump sum? Are you going to change to an accrual? What works best for your office? But again, update your policy to accurately reflect that. You want to make sure you've got up-to-date 2024 poster that has the new paid sick leave requirements posted in your office. You also will need to provide your employees with an updated wage theft notice. So this is for your hourly employees. This is known as the Labor Commissioner 2810.5 form. And that is that form. It's like a 2-ish page form where it talks about your paid sick leave. It talks about your workers' comp. All of that information is in there. That's a form you give everyone at hire, but you're also supposed to provide that to everyone when you've got a change like this, a paid sick leave change. So we advise everyone provide that new form. Of course, you're going to make sure you update your wage statements. So talk with your payroll provider to make sure they are up to date on California's new law. And then there are several different cities in California that have their own local sick leave ordinances. We are safe in Sacramento, El Dorado, Placer County. We are just going with the state. But if you have another office located in the Bay Area, make sure that you're checking out their specific paid sick leave requirements. All right, the other change that is affecting a lot of businesses, if you have 5 or more employees, is this new reproductive loss benefit or bereavement leave. Excuse me, it's a mouthful. Now, you might be very familiar with the general bereavement change that came out last year. They said all businesses need to provide, if you have 5 or more employees, 5 days of unpaid bereavement leave. There was a little confusion if reproductive loss was part of that. And so they have very much clarified that there is a reproductive loss bereavement leave available to employees. So in order to be eligible for this, your employee has to work for you for 30 days. You can limit this to 20 days in a 12-month period. There's kind of a long list for what this might cover, and it's here on the slide for you. But this could mean a failed adoption, for example. Maybe there was a miscarriage, unsuccessful assisted reproduction. So there could be several times during the year that someone could be going through that. So they get these 5 days. Again, it's unpaid time, but it is protected time, and it can be limited up to 20 days in a 12-month period. Now, what's different in reproductive loss versus the regular bereavement leave is you cannot request certifying documentation for this, as opposed to regular bereavement leave, where you can say, can you please provide a copy of an obituary or a copy of a program for a service that you went to, so an employee can show that they actually attended that event. For reproductive loss, you are just going based on the person telling you that they need some time off for that reproductive loss. So here are some guidelines for it. They do need to use that time within 3 months of that particular event. Now, if the employee is taking other time off, CFRA or FEMLA, that is standalone time. These two do not run concurrently. The leave also doesn't have to be consecutive. So maybe somebody needs 2 days off this week and they need to take 3 days off next week. So it can be intermittently taken. Again, it's unpaid, but employees can use any accrued time that they have. Remember, with paid sick leave, that's always at the employee's discretion when they use that time. Vacation can also be used. So this is where you'll need to update your bereavement leave policy to include this reproductive loss event. Let's transition over to some other new employee protections that you might have heard about. This kind of got more attention a year or so ago because people thought it went into effect last year, but it was just announced last year, but it's not officially in effect until now. It went into effect January 1st. But we have a new protected class in California. FEHA is the Fair Employment and Housing Act, and that is something that's managed by California Civil Rights Department. So now an employee who is using cannabis off-duty and away from the workplace is protected. The cannabis use rights are protected in California, which means you can't take any adverse action or discriminate against somebody who is using marijuana away from the workplace and off the job. But this still does not allow an employee to be under the influence and impaired by cannabis when they are working for you. So think of this the same way as alcohol, for example, or any other drugs. Marijuana is going to fall into that same guideline. Employees cannot be under the influence. They cannot be impaired. They need to be able to function fully and be able to do their job. Now, there's a couple of exceptions to these cannabis use rights. Construction, building trades, they do not have this protection in place. Department of Transportation drivers, etc. People for federal and state jobs. I always like to reassure people about that because people sometimes ask, they're like, everybody? But no. So just keep in mind, your employees are allowed to do that off of the job site and when they're not working, but they can't be impaired when they are at work. So where this is really coming into play is with drug screening. So if you do pre-employment drug screening, or if you do reasonable suspicion testing, both of which we recommend. We also recommend, of course, you have a reasonable suspicion testing policy in your handbook. You need to make sure that's in your handbook. But this is where you're going to have to kind of reevaluate what sort of testing you will do. And you also need to make sure you're doing the proper testing. So as always, we recommend you have your employees go to an outside clinic if you are doing pre-employment testing, or certainly if it's post-accident or reasonable suspicion testing. So now you are no longer able to test for non-psychoactive components, which can indicate use in the past couple of weeks. As you know, if you've dealt with doing drug screening before, they'll say, well, they've got some in their system, but it looks like, it's probably several weeks old or something along those lines. So here are your options. If you want to continue to test for marijuana, you're going to make sure you're using the right test. There are saliva compliant tests now that can test for that THC that shows up that it's very recent use. The urine tests don't work, blood tests don't seem to work, but the saliva test does seem to work. Or some employers are just choosing to not test for cannabis anymore. Again, it's completely your decision. Make sure you are working with a clinic, though, that is up to date on the rules and knows how to test properly and which test to use. If you need a good drug screening partner, we recommend OcuScreen. They're one of our partners, and they can help you out and make sure that you're doing the right test and going to the correct clinic, just to make sure you're being compliant with that. Now, another question we get about is, what can I put on my employee application about drug use or any felony convictions or anything like that? We'll talk a little more about that when it comes to that Fair Chance Act, but keep in mind, you can't ask your employees if they have had prior use or prior convictions for marijuana use. You're not allowed to have that on an application. You're not allowed to ask that in an interview. So there are a couple of exceptions under the Fair Chance Act, as I mentioned, but we'll talk about that here in just a little bit. But remember, if you've got that on your application, you want to remove anything that talks about cannabis use, anything that talks about a felony or misdemeanor, or anything that asks about salary history. That all needs to be off of your applications these days. A couple of to-dos for you for this topic. You want to make sure you are using the correct test if you are going to continue to test your employees for cannabis use. So make sure you're using that saliva-based or another compliant testing if your clinic says they have another type of compliant test. Make sure you update your drug policies. And then again, train your managers. I know some of you have multiple offices. You want to make sure everybody is on the same page and everybody is being consistent in how they manage that process for you. Couple of things with non-compete agreements. I don't see this come up too often in dental offices. Keep in mind, though, basically non-compete agreements don't exist in California. You might have one that maybe you've written up, you've held on to it for a long time, or maybe you inherited it if you purchased an office. Non-compete agreements really just don't work. And what has come about now with this big change is that there is now this private right of action if you violate these non-compete agreements. So even if you had one in place it's been in place for a couple of years, even if somebody was outside of California, California is really coming in and saying, nope, this is California. We simply don't allow non-compete agreements. So if that's something that you have or something that you've worked with, you really do want to make sure you're consulting with an attorney on that. You want to make sure you're auditing your employment agreements and your new hire letter or anything that you give your employees where you say we don't or we do have a non-compete agreement, simply not going to work in California anymore. So you need to get rid of that. Not only do you need to kind of end any non-compete agreements, but you need to send a letter to anyone who signed a non-compete agreement from January 1st, 2022 forward, and let them know that it's not in effect anymore. And you have until February 14th to do this. Add that to your fun Happy Valentine's Day list. But you do need to make sure that you're letting employees know that this non-compete agreement is void and it simply is not in effect anymore. Now, another reminder I always like to tell people, You need to send that to the last known address and email address of your employees. And you might be thinking, well, I had somebody who left a year ago. We had a non-compete agreement. I have no idea how to get a hold of them. Good practice: when someone terminates, ask them to provide you with the most recent mailing address and their most recent email address and their most recent mobile phone number, because those do change, and something you might have in your files from a year or two ago might be outdated by the time that employee terminates. So make sure you always ask to get that updated info from them. So here's one that I really want you to kind of take a look at. So this is Senate Bill 497, and this is called retaliation presumption. So if an employee comes to you and they say, I have a complaint about wages, I have a complaint about something that's going on in the workplace. If you take some sort of adverse action against that employer or employee, excuse me, if their wages are cut, if they are fired, if something happens to them, there's going to be a presumption that you have retaliated against them for coming to you with this wage claim concern. And the burden will be on you to prove that this action, this termination, this pay cut, whatever it is, was not related at all to them making a complaint. So any sort of protected activity. So this is where we really advise you. And if you've called the hotline, I'm sure any of my colleagues will say to you, document, document, document. If there's a performance issue going on, document that. If there is an attendance issue, document that, because the burden will be on you to show, well, no, I had to terminate this person because they violated this other policy. Had nothing to do with them coming to complain about a wage issue. It had to do with the fact that they had been absent for 10 days in the past 2 months. So be very cautious with that. Again, that's that 90-day window. So you're looking at 3 months of work, which is quite a bit of time. You want to make sure that you could show, if you ever had to, that you made a legitimate business decision as to why you needed to take that action against the employee, and it wasn't due to them complaining about a wage issue. So be cautious with that. So let's talk a little bit about those agency and regulatory updates. And this is the one I mentioned before, something called the Fair Chance Act, which you have probably heard about before. But this is the issue where, again, we can't ask our applicants about criminal history. So when they come in to fill out an application to work with you, we don't say to them, have you ever been in jail? Have you ever been arrested? It's simply not allowed. You can't inquire about criminal activity until you have made an offer to an employee. So it's post-offer, pre-employment, that's when you can do that background check. The other thing to keep in mind is when you get that background check back, you have to really evaluate it. You can't have an automatic rule that says, well, if anyone has been in jail for the past year, or if anyone has a DUI conviction in the past 5 years, I never hire those people. That's not allowed in California. What you have to do now is take a look and see if it has this direct and adverse relationship to the duties of what that person does. So this is a reason, while I will encourage you and remind you, make sure you have job descriptions so you can have a very clear breakdown of what an employee is responsible for doing. So for example, if you're hiring someone to work in your front office and you do a background check and it comes back and it says that they had a DUI 3 years ago, and they are never going to drive for you, they're not a driver, they're not delivering anything, that probably won't come into play because they're going to be front office, they're going to be greeting customers, they're going to be taking phone calls, they're going to be scheduling appointments. But if you had a person who did have a conviction that directly reflected on the job that they're doing for you, that's where you might have a little more leeway to say, well, this might not be the right applicant for this particular position. But you have to be very cautious about this. And this all came from the idea that we can't immediately exclude individuals that have a record, because again, there's that fair chance. They need to have a fair chance. But what they've done this year is they've expanded it to include employees who are applying for internal positions. So if you've got a DA and they want to become an RDA, or maybe they want to become your office manager, you can't automatically exclude them because you're aware of something from their past, or you learn about something from their past. So this also comes into play if for some reason, if you're selling your office, or maybe you're merging with another company or another office to become a larger group, you can't take any of these things into consideration. So you couldn't say to somebody who's buying your practice, well, I wouldn't hire that person because I heard they had a conviction. You're not allowed to do that. You have to be very, very cautious with that. So let me give you a scenario here. So you've got a manager who's having a casual conversation with one of your employees who discloses that she has a drug conviction. My manager now doesn't want to consider her for this promotion. Is that okay? Well, no. As we've discussed, no. We've got to first look at individuals based on their experience, based on their performance. We have to look at those objective job factors. So that includes a promotion, that includes, as I mentioned before, an office change or something like that. And this applies even if the employee volunteers this information and perhaps is oversharing. You can't just say, well, they told me about it, so now I can act on it. That's not how it is. Again, we have to consider these individuals as an individual, and we have to look at the whole big picture, which means employees now have an opportunity to provide you with some more information. So as I mentioned before, you want to do this individualized assessment. And I know we've got a couple of CEA members on the call with us today. So make sure, take a look, make sure you log into the website, and we've got some great resources for you out there. We've got a fact sheet on how to do this individualized assessment. But what you really want to take a look at, again, as I mentioned, the job description, what are they required to do? What is it that they are doing for your office? Are they driving? Are you a lab? Are you someone that's going to have an employee who's running errands for you all the time? Well, that might come into play, but then let's take a look. Was it 6 months ago or was it 5 years ago? And then if the employee presents some documentation to you, if they say, for example, well, I did have a DUI conviction, but I went to rehab, I've had a completely clean record, I go to counseling every week, and they provide you with some more information, you are now allowed to accept that as part of your consideration when you're trying to figure out, is this the right candidate? Now, you can't require it. So it's one of those things that employees can voluntarily provide it to you, but you do want to take it into consideration. Where this has come into play, where I've heard about it coming into play, if there is, for an example, a conviction of violence or something like that, and an employee comes to you and says, well, I was in a violent relationship and I was defending myself, and here is the police report, even though I had a conviction for it. Yes, it was assault, but I was defending myself. And so they might provide you with police report, medical records, those kind of things. So you do want to make sure that you accept that as part of that evaluation process. And of course, always give us a call on the hotline if this issue comes up and you kind of need to talk through it. So let's talk about the NLRA a little bit. Again, this is the National Labor Relations Act. It's such a mouthful. A lot of times people think, well, this is just unions. I don't have to worry about that. Dental offices aren't unions most times. This isn't going to affect me. Well, it is affecting more businesses. As I mentioned kind of in the beginning, there are some changes you'll want to make to your handbook where you're taking into account some of these NLR changes that have come along. So Section 7 of the NLRA applies to everybody, and that's the section that gives employees the right to talk about wages. They can talk about terms and conditions of employment. They can pretty much talk about anything they want to talk about, and you don't want to take adverse action against them. So that means if you kind of have a policy, especially if it's a written policy, you're going to want to change it right away. But if you say to employees, you're not allowed to discuss your wages with anyone else, you've actually violated the NLRA. So employees are able to discuss those wages if they want to discuss that. And we've had a couple of big cases in the courts, something to think about just as you're setting up your policy. And again, that's why I'd recommend you've got your 2024 updated handbook. But if an employer puts a policy in place that says you can't talk about these things or you can't disclose this kind of information, anything that you do as an employer to, as they say here, chill the employee's exercise of their rights. So just kind of say to an employee, you can't do that, or you really shouldn't do that. You have essentially chilled the employee's right to discuss those things, and you can be in trouble for doing that. Now, if you can show that there was some legitimate business reason why employees couldn't discuss those things, then you might have a little more of a case to stand on, but you really need to be careful. And we have a great article. I know many of you have probably talked to Eli on the hotline, and he wrote this article called Review Your Policies with a Magnifying Glass. You can just access that on our website. And it gives a little more insight into this. If you need a couple of examples, I'm going to give you one in just a second. But it is one of those things that's kind of a fine line. So let me show you an example. And kind of like the one I gave before. If you say to employees, you can't discuss your wages with anyone, Or if you say you can only discuss work matters with other employees who have a specific business reason to know or have access to that information, that's pretty limiting. But it would probably be likely that you'd be allowed to say, don't disclose confidential financial data or proprietary information to individuals that don't need to know about it. So it's kind of a fine line, but this is why you really want to take a look at your policies and make sure that you're being compliant with that. And again, you're not chilling an employee's right to speak about things that are protected. So a couple of to-dos for you here. Audit those job applications, as I mentioned. Take off anything with salary, criminal history, marijuana use, all that stuff needs to be gone. Make sure you train anybody who might interview. Again, if you've got multiple offices or if you've got a couple of people that interview, make sure everybody knows what those guidelines are. And of course, update that good old handbook. All right, so let's talk about wage and hour, because I know this is the one that you are dealing with all the time, every single day. All right, so here are our minimum wages and our exempt salary basis for 2024. So you might remember in years past, there were a couple of different categories depending on your employer size. If you were 26 or more, you paid this. If you were 25 or less, you paid this. That is all gone now, which is nice because we like to simplify when we can. And the rule is, if you have a non-exempt hourly employee, they have to make at least $16 an hour. So a minimum of $16 an hour. And that's absolute minimum. Got to make sure they're always making that. Now, the reason we need to pay attention to the non-exempt hourly rate is because that affects our exempt or our salaried rate employees need to receive. So what you do is you take that 16, you multiply it by 2, and then you multiply it by 2080, which is the number of work hours in a year, and then you will get the exempt salary requirement, which is 66,560. So anyone that you have classified as salary exempt needs to make at least 66,560 a year. Now you might be thinking, uh-oh, I have people who I'm calling exempt who don't make that much. Maybe they're at 55,000, maybe they're at 60,000. You might need to consider transitioning them from an exempt to a non-exempt employee. So we've given you some tips on that, and that's a bit.ly that's on this slide. You can take a look at that. Because remember, when you change an employee from exempt to non-exempt, they have to follow all the non-exempt rules. So that means they're clocking in and out to start and end their day. They're clocking in and out from lunch. They're taking their breaks and they're taking their meal periods. Now, the question we sometimes get is, what if somebody doesn't work full time? Can I pay them less and they're an exempt employee? No, you can't do that, because an exempt employee has to make that minimum salary requirement regardless of how many hours they work. If they work 20 hours a week or 60 hours a week, they still have to make the equivalent of 66,560 per year. The other thing to keep in mind is California automatically says employees are non-exempt unless you, the employer, can prove differently. So you need to not only ensure that your exempt employees are meeting the salary requirement, but they are also meeting the duties requirement. Now, for those of you on the call today that are dentists, you are automatically exempt under the professional exemption. So there's a professional exemption, a managerial, and an administrative. So for you as a dentist, you're automatically under that professional exemption. Most of your other employees, though, will not qualify to be exempt. It's possible if you have a very high level business manager or office manager who's very involved in the business operations, as in they make policies, they're leading the organization. It's possible that they could be exempt, but when in doubt, it's always much safer to have your employees be non-exempt and pay them hourly. Also, we get this question a lot. Hygienists do not automatically qualify for an exemption and are more likely than not a non-exempt hourly employee. So make sure that you have them classified correctly as well. And of course, give us a call at the hotline if you have questions on that. Another thing to keep in mind, as I mentioned, paid sick leave. A couple of cities have their own paid sick leave requirements. There's about 6 or 7 paid sick leave requirements. There are over 40 different cities in California, cities and counties, that have their own minimum wage requirements. They're mostly in the Bay Area, down in Southern California, again, in the SAC area, El Dorado, Alpine, all of our areas. We're just with the state minimum wage. But when you start going into the Bay Area, then you might see higher minimum wages. So again, you have to make sure that your employees are being paid properly. Now, I know most of you for your offices, employees aren't at minimum wage anyway, but it's a good thing just to check every now and then if you have employees that perhaps work at a Bay Area location, that you're meeting those minimum wage as well as those paid sick leave requirements. So let's talk about the other thing that I know you have to deal with in your office sometimes, employees using their personal vehicles for work. So if you've got your office manager and they are running out to the bank for you a couple of times a week, or maybe you send an RDA to go pick up Starbucks for everybody or sandwiches for everybody. Anytime that you are telling an employee that they need to use their personal vehicle to do something for the office, you need to pay your employees for not only their time, but their mileage as well. So we always advise that you pay at least the IRS rate. So every year the IRS sets a rate and they say, okay, this rate covers gas, it covers insurance, it covers general wear and tear on an individual's vehicle. And they said for 2024, that is 67 cents a mile. That's how much you need to pay an individual. Now, you're not required to pay an individual that. You can pay them less if you want. But if an employee incurs some sort of damage, if they get a flat tire, if they get keyed, if their car gets keyed in a parking lot or something like that, and you're not paying at least that IRS rate, they could have a pretty good argument to say, I want to get a little more money, or I want you to pay for that new tire. So that's why we always advise that you pay that at least 67 cents a mile. If you want to pay more, fantastic, because you never get in trouble for paying more in California. No one's going to come and say, I've got to pay you back right away. You overpaid me for mileage. They're going to smile and say, thanks, I appreciate that. The other thing to keep in mind, as I mentioned before, they're on the clock. Anytime you're telling them to do something, they're on the clock. So be very careful if you've got a non-exempt employee that you're sending out to go pick up lunch for the office, for example. You want to make sure they're paid for that time, but you want to make sure they're also not missing a lunch break that they're supposed to be taking, for example. So be cautious about that. Also, if somebody needs to drive somewhere, perhaps you have two offices and somebody is going between the two offices and you're saying, I want you to start at the office in Folsom, and then I want you to head to the office in Roseville. You are going to need to pay your employees for the time between those two offices because they're under your direction. You're telling them to go to that other location. And sometimes people will say, well, what if they do it on their break time or their lunch hour? It's not a break or a lunch break when you as the owner or the dentist are directing someone to do something for them. So you need to make sure they're on the clock, that's compensable time. And again, you're paying for that mileage. Anything above and beyond an employee's regular commute needs to be paid, and they are on the clock for that time. So remote work expense reimbursements. This has been one that has gone all over the place, back and forth, especially when people were working from home during the shutdowns. I know you certainly had your hands full dealing with all the regulations that dental offices had to deal with, which were a lot. And I know you might still have employees that maybe work from home a couple of days a week. Maybe your office is open Monday through Thursday, and then you have somebody who works from home on Friday. So if you, as the business owner, require or encourage remote work, you should look at reimbursing some work from home cost. So that could be a portion of individuals' internet that they have to pay, office equipment. Of course, you need to make sure somebody has a laptop or any other equipment that they might need. If they need a printer, those kind of things, you need to reimburse some of the costs that they incur in using those devices. Also, personal phones. This is kind of the one that keeps coming up. I just talked to a dentist the other day that said a program that they're using is now requiring a two-factor authentication. And so employees are having to log in on a computer, and then they're having to get a code sent to their phone as well. So their employees have started using their personal phones for that. So if an employee is required to use their personal phone, then yes, you need to reimburse them an amount for that use. Here's the problem. The state has never come up with here's what we recommend you reimburse people, which kind of would have been helpful. They have come up with the term, a reasonable percentage. What is reasonable? Hard to say with clear definition, but what we recommend is you come up with an amount that you think is reasonable. So for example, if you have an employee who works from home 1 day a week, they're working 20% of the week. If you reimbursed 20% of their internet cost or 20% of their mobile phone cost, that would probably be a reasonable amount. What we do encourage you to do is come up with an agreement as to how much you'll be reimbursing those individuals, have them sign off on it, and then add some sort of statement that says, if you feel that this reimbursement is not sufficient, contact your supervisor, and then you can have a discussion with them where you say, well, you need to provide me with some receipts, or let me see some backup information so we can find out what we need to reimburse you. And I see we've got a couple of questions coming in. I will jump to those in 1 second after we talk about our to-dos here. So again, check county, city minimum wage laws if you have employees that are traveling outside of the Sacramento area, especially again, Bay Area, Southern California. They might need to be paid a little more if they're at minimum wage. Of course, make sure you've got your 2024 poster up to date. As I mentioned, make sure you put an agreement in place if an employee is working remote, and also pay your employees for any time that they are traveling above and beyond their regular commute, and make sure they're on the clock for that. And then budget for any of those minimum wages. And the questions have magically disappeared from the Q&A box. So I don't know what happened to those, Anna.
We had an accidental paste, but I'm just going to go ahead and help Jen out. This is in regards, excuse me, this is in regards to the IRS mileage. She asked, do you have to pay the hourly rate, or is minimum wage acceptable for travel time?
Ooh, Jen, excellent question. Yes, you can pay a different rate of pay for training and travel. So yes, as long as it is minimum wage, that is fine. But if you have somebody who is traveling to an area that has a higher minimum wage, so for example, if you send employees to Emeryville that has a very high minimum wage, you would need to make sure you are paying the minimum wage if they're attending training in Emeryville. So be careful with that. You can also say that you want to pay just a slightly lower wage. So maybe, and I know this comes into play for hygiene because your hygiene are highly compensated individuals. So maybe you just say we pay training or travel at $20 an hour or $21 an hour or something like that. You can set a different rate, but yes, as long as it's minimum wage, you are able to do that. All right, let's see.
All right, thank you.
Okay, thank you so much, Anna. I think we're caught up, but go ahead. Any other questions, throw them in the Q&A box and we'll get to them. A couple of quick safety updates. As I mentioned, this is coming in July of this year. It is another acronym because we love acronyms. It's the WVPP, which is your Workplace Violence Prevention Plan. So I know many of you are very familiar with an IIPP. That is the Injury Illness Prevention Plan. This is going to be separate. Well, we recommend it separate, but this is going to be something where you will specifically document when there is some sort of violent incident in the workplace. Now, this doesn't go into effect until July. You have some time. Some of you might be exempt from this. If you have a lot of employees who are teleworking, and I know we kind of have a wide range of people that might be on here, places with fewer than 10 employees at any given time and not accessible to the public. I don't think that's going to be it for most of your offices, but if you do have an office situation like that, maybe you have an offsite admin office, they might fall under some of these different rules. But healthcare, Department of Correction, law enforcement, they all have to do this anyway. We kind of recommend it for everyone. But what you're going to do is create this workplace violence prevention plan. What you will do is record when there is an incident. And I'm going to show you a couple of examples of what those might be. Again, as I said, we would recommend you do this as a standalone document. Keep your IIP separate from your WVPP. So if one needs to be updated, you don't have to update both documents or the entire document. But the new thing that's coming with this is that you are going to be required to do some training. You're going to have to do annual training on what your workplace violence prevention plan is all about. And you also need to make sure that you are maintaining training records for a year. So this is one of those things where I would recommend at your new hire orientation, we always advise take care of your harassment prevention training at that time. You will now be adding, as of July 1st, this workplace violence. So what are some of the examples of recordable incidents, and especially what are you going to have to think about in a dental office? So, and I hope none of these ever happen to any of you, but if there is some sort of physical attack with or without a weapon, If there is a threat, somebody threatens an employee, threatens the use of a weapon, threatens beating them up, something like that, that would be recordable. If there's any sort of assault, that would also be recordable. Any sort of physical sexual conduct, that would also be recordable. Or an animal attack. I know you might have some of your patients that might bring in a service animal. And if there is some incident with that animal, that's one of those things that would now be recordable. So this could also fall under if there are fights between employees. If there is some sort of threat from a customer or a patient, or even a third party, somebody that comes into the building, those things would be recordable. Now, we don't have a lot of information on this quite yet, and I'll show you why. We're waiting for some more guidance, but they are asking employers to put this plan together by July 1st. So what I would encourage you to do as we're waiting to get some more information is figure out who's going to be responsible for this. This would be whoever is in charge of safety for your workplace. They might do your general exposure control plan, your safety in general person. Get this kind of on their radar so they know about it. And that might be you because you're probably wearing lots of hats. But again, you're going to deliver training in July and then every year thereafter. So July, this is going to happen when employees are hired. And then every July, you're going to make sure your employees get trained. And then when you put this plan together, and again, we're hoping to get some more clarification from the state, but you will want to do inspections. This could be just where you're securing any back doors that where other people might have access to your building, making sure only people can get into the building who should be able to get into the building, any other safety issues, those type of things. It'll just kind of be another step of your safety process. And of course, record retention, as I mentioned, you're going to hold on to those for 5 years. Sorry, the other thing I wanted to mention about this is they aren't putting out a lot of guidance on this quite yet, because this was actually something that the Assembly did, and this wasn't something Cal OSHA did. So Cal OSHA actually has until 2025 to come up with official regulations on what needs to be in this plan, but we're expecting to get some more guidance. So this is a reason to stay tuned to our newsletters, make sure you're getting our emails, and we will keep you up to date as we have some more information on that. All right, so tiny slide on COVID, because I know we're all tired of COVID, you more so than anybody else, because I know dentist offices had a lot of challenges during COVID time. But keep in mind, we still have these COVID permanent standards through Cal OSHA. Those are in effect through February of next year, so through February of 2025. And then there are some record keeping requirements that go all the way to 2026. You are still required to have your COVID prevention plan, that's your CPP. You need to take a look at the new guidelines that CDPH has put out. So the California Department of Public Health significantly lessened their guidelines and requirements when people are testing positive, depending on if they are symptomatic, non-symptomatic, fever, non-fever. So take a look at all of those guidelines. I know you're probably getting lots of information from SDDS or CDA on those things too. Stay up to date with those because they are ever changing, and they're also kind of quiet sometimes when those changes come out and they don't make a big announcement about it and then people don't know about it. So make sure you're following along with those guidelines. If you are a CEA member, we do have that great COVID toolkit that's on the website that you can use. So make sure you're referencing that. That has been updated. The good news is, as of January 1st, you no longer have to contact your workers' comp carrier when employees test positive. So you can take that off of your to-do list. And you no longer have to post that big posting that says, there was an incident of positive COVID in our building, in our office, anything like that. You do still need to notify anyone who is a close contact. So for most of you, for your offices, if somebody tests positive for COVID, you can just send an email. Of course, we never say who is tested positive because we don't disclose any medical information, but you can just say that an employee tested positive, and you can, then attach a copy of your CPP, your COVID prevention plan, any of that information guidelines that you like to provide to your employees, and just again, let them know what the resources are if they need to get testing or if they want to get tested, if they're feeling symptomatic, what they should do and follow all those guidelines. So not a lot of changes with COVID. They're certainly lessening the requirements at the state, which is nice, makes it a little easier for everybody to manage that and kind of go on with the day-to-day. All right, so what I have on the screen for you now are the HR codes. So I wasn't sure if we have a lot of HR professionals on the call, but if you do have your HR certification through SHRM or you have it through HRCI, these are the codes where you can get an hour of credit towards your recertification. Now, this is just for HR certification. As Danielle mentioned, she is going to send out your CE credit. So if that's something else you need on the dentist side, she's going to take care of that. But if you are an HR person and want to get a little more credit for HRCI 651637, SHRM is 24-SATD5. So make sure you get credit from the HR side, but then also make sure you do everything that Danielle needs you to do so you get CE credit on the dentist side. And then last thing I just wanted to pop up, I know a lot of you know CEA, and again, I know we've got some members. If you need a little extra help and you think, gosh, I need more help than just the hotline, we've got a whole team that can assist you with that, a couple of different levels of membership, or if you just want full access to our website for all the forms and toolkits I've talked about. Here's quick little information, but of course, just give us a call on the hotline and we'll put you in touch with our HR services team, and everyone will be happy to help you. And then I just wanted to say, I know we've just got a couple of minutes left. So if you have any other questions, just pop them into the Q&A box. I'll be happy to take a look at them there, because if you have the question, someone else might have the question. And Danielle added, for attendance verification and to get credit, add your name here in the chat box. If attending as a group under one Zoom account, please type in all the participant names in the chat box, because you certainly deserve to get credit for sitting through today's training. So this is our survey. We would love to get your feedback on what you liked or didn't like on today's training, or what other trainings you would like to see. So you can use your fancy phone and do that QR code. You can let us know anything that you would like to hear about, because we always love to hear what trainings you would like to have in the future. And of course, your last reminder here is that beautiful HR hotline that SDDS provides to, which is an amazing benefit. As you saw probably from that price sheet, I mean, it's almost $1,000 benefit that they're giving you as a member. So it has wonderful value. So give us a call. We get tons of calls. I mean, literally hundreds of calls. I promise you're not alone in your questions. We get lots and lots of calls from SDDS members, but 888-784-4031. Call and chat with me, anyone else on the team. I know everyone's chatted with Craig and Eli and Joanna and everybody, Juliana, Jessica, everybody's amazing. So feel free, give us a call anytime you have questions. We are always happy to help you. And with that, I will say thank you so much, everybody. Any other questions? I didn't see any more in the Q&A box, so feel free, give us a call on the hotline. We would love to talk with you. And anything else before we say goodbye, Danielle?
That is, I think you're correct. I don't see any in the Q&A box, but I'm sure they will be utilizing that phone number. So thank you so much, Mary, for some really wonderful information and a wonderful program. And thank you to everyone attending. In order to help SDDS maintain and improve our program quality, please take a moment to complete the survey that you will receive via email. Your CE certificate will be attached to the survey for immediate download. And as always, thank you so much for supporting SDDS. That's it for me.
Bye, everyone. Thank you. Cheers.
Bye.